So I hope that this event will help us as a law school, as a faculty members, to understand what is the data privacy law. I know a little bit about data privacy law. I'm not that expert. You people are super expert in data privacy law. But we would like to learn from you that how event will help us as a. Okay, fine, maybe some. So Navi sir, I will stop here, and I congratulate you to organize this very quick industry focused data privacy webinar. And I strongly believe that this webinar will give a lot of understanding, and it will really demystify this bill to many students and working professionals. So again, thank you very much. And I also like to thank my colleague, Dr. Tulika Shri. She is working in MLS. She is very bright faculty, LLM from NLS Bangalore, PhD from NLS Bangalore. And so Tulika is also expert like in competition law. So me and Tulika, we are working together with FDPPI, and we are expecting good outcome of data privacy law and regulations in next 1 year. Tulika, thank you very much for your help, and over to Navi sir.
Thank you, sir.
Thank you, Avinash. For those of you who are not fully aware, FDPPI and Manipal Law School are entering MOU for collaboration, not only for the next upcoming IDPS 2023, as well as for collaborating on conducting of other seminars, maybe more roundtables, and also in organizing some MDP programs, as well as contribute towards their LLM, which is having some component of data protection law. We are very proud to be associated with MLS, which is part of the Manipal Academy of Higher Education. They have a beautiful premises in Yelahanka, and equally well-equipped and very impressive auditorium, like all major educational institutions. And definitely we will be happy to be working with them. In fact, we were discussing last week when we met him about conducting roundtable conferences on different aspects of say DPDPB as applicable to different sectors. You know that we conducted in June the impact of DPDPB on health sector here. And we are now planning to have an event in Chennai, if possible, on retail sector, and maybe on other segments sooner or later. So when suddenly this particular bill came, I thought, and one of our members also suggested we cannot have a discussion on the DPDPB. Then we thought that this is the right time, a roundtable, at least virtually, and associate MLS also as part of this activity. So that's why we are here. Now, we have, of course, here a number of professionals. Many of them are from our FDPPI community, and there are people from outside FDPPI community also. And as we have observed, this time there has been a lot of awareness about the data protection law. So that the law came on 3rd August, yesterday in the afternoon. But by today, you can see not only a number of articles in newspapers, there are many experts who have also recorded their views on the bill and analysis of the bill. And there has been a lot of information which is available for our reading. Of course, as I was discussing with somebody earlier, we have, of course, two kinds of, say, people who make comments on such bills. One set of people who are critical of the bill, and they always say that why don't you put it up to a joint parliamentary committee so that let it go for another 2 years, kind of a thing. There are very few people who look at the glass as half full. And FDPPI actually belongs to that rare segment of the market which tries to look at what we have achieved with the bill so far, though we could have achieved a lot more. In fact, here we have both the advocates and law professionals who look for how the bill is protecting the privacy right of an individual, what are its shortcomings, and so on. We also have industry people who are actually looking at how this act will affect their day-to-day activities like collection of personal data. So probably we will try to address the concerns of the industry, because compliance is what we are looking at. Now, whether the data protection board is having a good composition, whether good people will be there or not, definitely a concern as far as the government is concerned. But for a company, I am only looking at what are the data protection principles which are there, what are the rights I have to do, what kind of penalty I have to bear. So our approach, which even during this particular conference I would like to follow, is look at the impact of DPDPB on the industry, and then let us discuss around that. Obviously, there will be people who would like to discuss about the various media reports on what should have been done better and why there is a lot of issues associated with this. But I suppose most of you will agree that let us focus more on the positive aspects of the bill. Now, with this, I would like to start the discussion. Of course, this is a roundtable conference, so any of you could perhaps be able to get on by contributing your thoughts. But my request to all the speakers is keep your response short. Maybe you can come multiple times rather than taking more time for one specific question. Okay, so let us first start with one of the issues which have been making rounds. That is, does this bill become a finance bill, obviating the need for passage by Rajya Sabha? This is one of the issues which many people are expressing, that since there is a presidential consent to treat this bill as a money bill, and that small communication was attached to the papers which were submitted or tabled in the parliament, there is a feeling that the government is trying to ensure passage of this bill with its majority in Lok Sabha, so that any remote possibility of the bill getting stuck in Rajya Sabha is reduced, which is important for us, because if it is so, then the bill will get definitely passed in the next 1 week or 15 days or something like that. So that is one issue I would like the experts in this group to comment as to whether they consider this bill as a finance bill so that it can get through faster. Yeah, Mr. You have any thoughts on this?
Sir, good evening. As far as I had gone through this particular bill, it was presented as a general bill. That was the clarification what I read from IT Minister.
Yeah.
So my understanding is it is not finance bill, and anyway, if it is put into that particular category, it would be certainly challenged. That is another legal point. But whatever I limited read about, it is not a finance bill, it is general bill. That is the statement of minister.
Yeah, in fact, this was one of the objections raised by one of the opposition members, and Mr. Ashwin immediately clarified that this is being presented as a general bill. And even Mr. Rajiv Chandrasekhar, in his interview, which was published by NDTV today, he has also said it is a general bill. Okay. Now, what makes this bill look like a finance bill is, one, the budget for this particular setting up of data protection board, which is 25 crores, is expected to be given from the Consolidated Fund of India. Secondly, any penalties which are collected are going to be credited to the Consolidated Fund of India. We know that Data Protection Board is a body corporate. It will have its own existence. There will be perhaps a bank account in the name of Data Protection Board. And in the case of GDPR supervisory authorities, most of them collect the penalty in the name of the supervisory authority. Okay. So here the government is saying that the penalties collected will go directly to the Consolidated Fund of India, and for future expenses of the Data Protection Board, the government will separately allocate the money, so that there is no incentive for the Data Protection Board to actually impose fines, so that that will increase their revenue. This is one of the charges I had on many supervisory authorities of the GDPR, particularly the Luxembourg Supervisory Authority, which imposed $887 million US fine on Amazon for a country which I think has only about less than the population of Bangalore city or something like that. Okay. Okay, that is the way they look at it. So this fact that money is being drawn from Consolidated Fund, credits are being given to the Consolidated Fund, I think that is what has made the nature of this bill more like a finance bill. So I want Mr. Avinash, you have any comments on this, or Kodanram?
Yes, sir.
Yes,
I
sir.
have to tell you, it's very narrow-minded approach to treat this as a finance bill, first of all. Because what is more important is not the revenues aspects. The purpose of this bill is to see that the rights of the citizens are restored to the required in the section 21, Article 21 of the Constitution of India, right to life. Putta Swami, when we remind of that Putta Swami judgment, it is Article 21 should prevail. That is the purpose of this bill. Through this, by penalizing, we get revenue, and therefore it should be a finance bill. It's a narrow approach. It is not a finance bill. This is setting right the rights of the individuals, vice the fiduciary or the business people. So there is need of a harmonious reading of it, and it's the distribution of rights which should give a prominence, and penal measure is only a byproduct. And it is not even a byproduct. We should not say we should encourage penalty schemes in this. It's only an avenue to bring that kind of harmony, and therefore this is a general bill only.
I accept your view as an ideal view. It should be considered as a general bill. It should be debated for a couple of days in Lok Sabha, a couple of days in Rajya Sabha. Everybody should agree. All that is fine. It is the ideal state of affairs. But I don't know whether say Aadhaar bill was passed like this, because otherwise Aadhaar bill would have never passed. Now I would like experts like Avinash also to add their view.
Sir, I think the debate, like, okay, in this context should not be whether it's a finance bill or not a finance bill, but then there's a very interesting debate at the regulatory law side, that the autonomy of the regulatory bodies. So once the government put a regulatory body under one ministry and they allocate the budget for day-to-day operations, their recruitment, and like for everything. So this is how we really limit the autonomy of the these regulatory bodies. And what we have seen in past, in India, like many regulatory bodies, the upcoming dynamic regulatory bodies in India could not function just because they never had any independent financial resources. So when the government wants to kill some regulatory body, they stop their finance, they stop their, like the cash flow system. So I think we also need to understand that from the Data Protection Board, a lot of things are going to happen in next 4 or 5 years, So, as a regulatory lawyer, I can say that we should debate also that do we need to give some financial autonomy, and operational autonomy is directly connected with the financial autonomy. That happened with the CCI also. So if you see the growth of CCI in last 10 years, you see their budget is not increasing in last 8 years. Okay, the budget which they used to get from Ministry of Corporate Affairs is almost same in last eight years. So I think this is another factor which we need to think about.
Yeah.
Sir, I think you had raised very valid point, because if it is also commented that if it is under control of government, the Data Protection Board, then certainly it will be dumping yard for old bureaucrats or favored peoples. So it should be what Mr. Avinash said. That should be the view, that this particular regulatory body should be autonomous and it should manage its own funds. That must be the voice of people who are concerned about data regulation in India.
Now, let us go directly to the composition of the Data Protection Board as per the bill. I'm sure that somebody like Manju or others will keep the bill ready so that if there is a need to read out, you please kindly do it. So as we have seen, the latest version, DPDPB 2023, has reverted to the where the board was supposed to be configured in the earlier version of the bill, that is the DPA 2021. In between, whatever was there as DPA 2020, the DPDPB 2022 had a very loose way of structuring the Data Protection Board. In fact, it said it is like a CEO being appointed directly by the government. But this particular version of the bill says that it will be an independent body corporate having its own office. It will be located at one particular place, say Delhi. It will have a chairman and not six. It has not mentioned the number 6. Okay, and it will have members, and all of them will have different kinds of expertise relevant to data protection. It is not that the chairman will be a retired judge or something like that. And in fact, it says in the entire board, at least one person should be the legal expert. The other person could be a data science expert. He could be a law expert. He could be an AI technology expert, data scientist, and so on. So what they are trying to look at is a board with different skill sets required for this regulation of this very complicated entity, Data Protection Board. I don't know, say, just because the government is ultimately going to be the owner of governance of India, we should say that every official will be an agent of the government. See, there have been Sheshan kind of people who have come from the current government appointments itself. Of course, the Election Commission and others, they have got a recruitment system where there is a committee of the Prime Minister, the leader of opposition, as well as the CJI. That has not been indicated here, but they have specified certain qualifications. And if the government does not adhere to that, obviously it will be questioned in judiciary. If tomorrow they appoint somebody who is not qualified for the job, definitely the court can perhaps intervene. So that is how I look at it. Until somebody is pointed out, we have to keep our fingers crossed and say that we will have an independent person. Yeah, Avinash, yeah.
Sir, I'm sorry to spoil this party, but it looks like that it's going to be a long litigation before this board starts functioning. The problem is, you see in this act or in this bill, there are a lot of ambiguities. So if you remember, see, because I work with Competition Commission of India, and so if you see the Competition Act was enacted in 2002, Then the Brahmdutt versus Union of India, someone moved to the Supreme Court, and there was a lot of debate that who should be appointed, what should be the criteria. There are a lot of ambiguity in the act. So it took from like 2002 to 2009. It took minimum at least 7 years to start the act. The section 3 and 4 of the Competition Act was notified in 2009. So see, I don't know why government is not learning from this thing, that India is a very litigation friendly and our courts love litigation and all these things. So very soon, I'm sorry, but I don't want to be wrong side, but this act, this bill invites a lot of litigation, especially at the composition and appointment of the members and chairmen. Then there is another point, the quorum of the forum. See, what you see in the Indian Supreme Court, it's well settled that you need to put a quorum. Even they haven't mentioned the number of the members. So all these things, ultimately, if the government doesn't correct them in the parliament, then matter will go to the Supreme Court, and Supreme Court will correct everything. Then they will give direction to the parliament. Parliament will come with Amendment Act. So I don't want to see this thing, but that has happened with the competition law from 2002 to 2009. And 2007, they came up with an Amendment Act. They streamlined the process. And this is how, I believe that it's going to be more litigation in coming 6 months or 1 year about this bill and act.
A notification on digital media regulations has gone to the Supreme Court, and almost anything which the ministry does, it goes to the Supreme Court, and definitely this will also go to the Supreme Court. There is no doubt about that. Now, one thing we have to remember is our Information Technology Act had this section 43 capital A, and this is supposed to replace that 43 capital A. So therefore, there is a close link between Information Technology Act and this proposed act, as if this is a continuation of the ITA 2000. And ITA 2043 capital A spoke of something called due diligence. Okay, that is a reasonable security practice includes the concept of due diligence. Now, due diligence is a open-ended concept which talks of best practices in the industry. So if there is a bill, many of the provisions of this bill will be perhaps construed as best practice to be followed even under our current Information Technology Act. So once it goes into the discussion, I feel that there is a value which the bill will have. Beyond that, none of us have got anything, any control on the matter not going to the Supreme Court. It will definitely go to the Supreme Court, and Supreme Court will take its time. So whether it will completely give a stay to this particular bill, or they will come back with their views subsequently so that amendments can be passed, that has to be seen. Any other person wants to comment on this? The 2 points which we have discussed so far is whether this is a finance bill. Most of the people, of course, said it should not be a finance bill. That is a different thing. But incorporating that section, that paragraph saying that President has given an assent, is it an indication that it is planned to do that, is one aspect. Second, whether the Data Protection Board is being constituted. Avinash has pointed out that by not giving the number of people and not defining the quorum, whether it will be considered as a lacuna, probably, so that on those things, anybody else have got any views?
Yeah, I would like to have one issue clearly, sir. This has been the problem from the beginning. Whenever we are, especially a committee is made or a tribunal is made, whatever may be, we are keeping it in a very ambiguous state. It is for the government to state at least who are the eligible members, what will be the type of people they are, what is the number. There should be a kind of a finality. Whether people agree or not is secondary. But when you know these are all the issues that are going to be taken up into the court regularly, why they are still want people to go there? Whether they are well-intentioned If they are well-intentioned, they could have incorporated the lessons from there. That has not happened in this specific board which they have formed. Board looks like a blackboard only. There is nothing clear about it. That's my...
Okay. Anybody else? Padamalai, do you have any views? Any other person with the legal background? I think PB Vishwanath has not joined. Anybody else who wants to speak about it before we go into the next topic? Okay. Now, one other important observation we have is that there are these basic requirements like the data protection principles and the rights. Now, on these 2 points, do you think the bill has given adequate coverage on the principles of processing, which is lawful basis, consent, etc., and the rights? Any thoughts on this? As you know that on the rights, we have a correction. Right to erasure is a slightly gray point. Right to nomination is there. Right to grievance redressal is there. Portability and right to forget are 2 aspects which are not specifically mentioned here. So on these aspects, any comments? Yeah, people like Anirban should have some comment.
Thank you, Navi sir. First of all, if I just give my view on the bill, this bill is in its simplest form, to be honest. And this is much more simple than what we have seen back in November, December time in 2022. Regarding the duties to the data principles, sir, I think this is sufficient because I think what government is trying to do, they're trying to keep the responsibilities and duties of data fiduciaries to the minimum so that business don't have to worry quite a lot around this. And as we all know that government is working towards a comprehensive legal framework which is called Digital India Act, and this is just one wing of the Digital India Act. Considering there are a couple of wings are yet to come part of this Digital India Act, I personally believe that this is sufficient as it specifically categorize data fiduciary and significant data fiduciary, where data fiduciary have certain average responsibilities and significant data fiduciary will have more strict responsibilities or to abide by. I'm pretty much comfortable, sir, with the bills considering the data principle, and moreover, this bill also take care of that no data principle misuse the power or the rights to the extent of this bill. So this is also a positive side.
You're talking of the duties expected out of the data principle.
Yes, sir. So this is pretty much quite comfortable, and I think business should not have any challenge accepting this bill. Apart from what our experts have already mentioned, especially the previous concern around the data protection board, because there are quite a few gray areas which need to be declared. For example, the blacklisted countries, what would be the threshold of processing activities which will decide significant data fiduciary and stuffs. So yes, an establishment of board is really required to make this bill fully up and running. Yeah, so Brad, sir, anything you want to add?
Ramesh Kota, do you have anything to add?
Good afternoon, sir. Nothing specific. I think most of those things done. From a technical aspects of it, that's where I'll be able to comment, not more the legal and other perspective. But from a production perspective and an individual side of it, I think it's covered of all the aspects of it. But the consequences of some of those activities, actions, I think may have to be defined in terms of the design by privacy by design, etc. So those are kind of an activities may have to come in, and we also need to see how they'll help the legal teams to handle it, because I think that part is still not clear. I guess that's what my reading is on.
Yes, on the data, processing principles. For example, consent. Consent has been mentioned as the lawful basis which has to be taken into account. Unlike GDPR, which lists 6 different things and says any one of these can be considered as a lawful basis. Here, of course, you can always read the legitimate users along with the consent as additional means of processing without a consent. But what is the view of this group as far as consent being made almost mandatory, unlike GDPR? Of course, in GDPR, we know that even though the GDPR said consent, contract, etc., and any one of these above can be the lawful basis, when it came to the cases, at least in the case of Meta, one of the supervisory authorities rejected the contract as the basis for processing and said, no, you should have taken a consent. So the supervisory authority went against the GDPR and preferred to have consent. Whereas in India, we are not given that option at all. Consent has to be taken. And one of the things which has been said is about legacy data. Consent is required even for the existing data which is being processed. On this, anybody from the industry have any specific concern or viewpoint?
Good. For this, banking and finance sector are going to have a big challenge.
Yeah.
Obtaining the consent from the existing population of account holders is very, very difficult. So they will definitely be failing. But in rural areas, people are not capable, the branches are not capable to handle this particular job. That is my experience from the banking industry.
Yeah. Dr. Naveen, you have any specific thoughts on this? You can unmute and then speak.
Sir, one thing I just want to add what Mr. Adipus sir said. Yeah, that's going to be a challenge, because I think a lot of data is already gone to various players, and then we don't know how they'll handle it, how they can come up. From a banking perspective, I would actually see that they will come up with kind of I would say a logic which says that unless you withdraw it, I think it is deemed acceptance. So that way, if I don't go to the bank and say that I withdraw as an eligible person,
yeah,
that means it will be given as a deemed consent. I think that's a route they might come up. Maybe wording could be different and legally. So that
is already there in there. Anyway, yeah, Dr. Naveen, you wanted to say something.
Yeah, I was going through that bill which has come up. So like about consents, it will be a great challenge, because introducing the technology which gives the consents. Let's say there's a CRM or any software or the application which the people are using. They have to integrate the consent into each and everything when they are sending the data to someone. So that is the big challenge which the industry is gonna face, right?
Yeah, just to expand on what Ramesh Kota was talking of, Section 5 talks about the notice. Subsection 2 talks about the prior consent, let's say legacy data. It says that this is again a difference between the earlier version and this. It says that as soon as possible, you try to get the consent. There is no mandate immediately. Second, it says the data fiduciary may continue to process the personal data until and unless the data principal withdraws his or her consent, which means that in the case of legacy data, where consent has been obtained, see, there are many instances where consent might not have been obtained because presently the law was not strict enough. But suppose consent has been obtained, then those companies which are processing that data will have some time to actually get fresh consent based on the current law. Okay, previous consents, let us say it has been obtained on the basis of Information Technology Act. That also had this consent for a specific purpose, and the rest of the things. So only this withdrawal of consent and other things were not as strict as this grievance redressal. All these things, some the new consent will have to be a lot more broader than the earlier consent. But if a consent has already been obtained and you can perhaps show that evidence of prior consent, then that processing need not be stopped forthwith. I think this is a big relief for the industries because it is not going to result immediately in discontinuance of the activity. Yeah, Mr. Nag wants to say something. Please go ahead.
Satish Nagendra.
Nagendra, okay. Nag is name, so I get confused.
I know, I got you. So
Yeah.
my point was, I understand that the people who are there in metro cities, who are a bit of educated in IT, I understood all of it. They'll be in a position to understand what is privacy and protection, everything. But how do we take it to the rural part of India? Unless it becomes easy for them to understand what is the meaning, how do I use, what are the rights? I mean, I see kind of a challenge there to prepare this rural part of India to get them, on this kind of a bill.
Think about the consent manager kind of arrangement. The consent manager is expected to bridge the gap between the data principal and the data fiduciary, so that in the case of rural people who may not be aware of privacy rights, language may be a constraint. Of course, the current notice says that privacy policy will have to be in all the scheduled languages. But these consent managers, if they come up, of course, it will take a little time for these consent managers to come up, because consent managers are also data fiduciaries, and they will have to acquire these data principles and then negotiate with data fiduciaries and say that whenever you want to take consent from my client, then you have to contact me through an API or something like that. I will give consent on behalf of the data principal. And then it is my responsibility to explain to the data principal what are his rights and what are the requirements of this particular data fiduciary, and manage that no excess permissions are taken and so on. At least this concept has been introduced in the law, and how far it is going to be used, we have to wait and see. But Nagendra, don't you think this will help us to achieve the concern which you have stated? Yes, good. Yeah. Anybody else who wants to add to this?
I would like to add, sir, this consent manager is going to add value for our youngsters who want to have their enterprise set up.
Okay, you say that is a business which can be
like similar to in GST, we have patent agents. So all situations where they are like bridge between the government, here they can be bridge between the principal and the government and through the fiduciary. So they will get a very good control on the principal's informations, and they will be better managing it. And it's a very good opportunity for them to charge something to the principal.
Yeah, correct.
It can be a very good enterprising one for a future, an opportunity we can think of for our youngsters.
Individuals can become somebody like agents kind of a thing, because these people also have to be registered as data fiduciaries. So probably they will have to be organizations who create a business around this concept of a trusted repository of personal data. It is like the proxy ID which UIDA is doing. Okay, proxy Aadhaar creation. These people will have to create a proxy ID for their clients with whatever pseudonymization they can do, and try to distribute the personal data based on the purpose requirement, they will be able to follow up on the withdrawal of consent, asking for erasure, all those things which an individual data principal may not be capable of doing. So we understand that India, there would be a problem, but there is a solution which has been suggested. And of course, it will take a couple of years for this to actually come up. Okay.
So, sir, this consent manager can be a person and can be a platform also, right? We see that, which allows data principals to manage and withdraw consent.
Yes, let us not confuse with the platform concept which is there in the aggregators in the finance system like the RBI, which is having the KYC aggregation and so on.
Right.
Platform. Okay. Like something data is coming from one data supplier and it is going to the data receiver. But here, this data protection law will be a data fiduciary who will have visibility of the data. Say in this platform approach, as a platform owner, I don't have to know whose data is going where and what data is going. I have to only create that pipeline and ensure some automated data flow. Like suppose I say Aadhaar number so and so, I want the information. It will automatically go to UIDA, fetch that information and provide it. But this data protection related consent manager would be slightly different. He is a person who will have a kind of visibility on the data. I feel they can give value by providing pseudonymization, de-identification kind of services to the data principal. Yeah, Jagannathan has something.
Yes, sir. Yeah, what I wanted to see, the bill says very specific obligations, even for the data principal, data fiduciary. But if consent manager has such an important role, there is no mention about specific obligations of consent manager. Consent manager
No,
also
it is there, sir.
It is there.
It is there. Kindly look into section 6, subsection 7.
Oh, okay.
There, the data principal may give, manage, review, or withdraw her consent to the data fiduciary through a consent manager. The consent manager shall be accountable to the data principal and shall not act on her behalf in such a manner and subject to such obligations as may be prescribed. So there are going to be regulations in place. And clause 9, every consent manager shall be registered with the board. Very important. They cannot be anybody can do that. No, they have to be registered, recognized. Maybe some entrance test they may conduct. Shall be registered with the board in such manner and subject to such technical, operational, financial, and other conditions as may be prescribed through rules and regulations. So there is a huge scope. It has been mentioned.
That is what I meant. In there any regulation governing consent manager?
Yes,
okay.
Yes. Yeah, Dr. Anirban.
Sir, regarding this consent manager, this consent and consent manager, whatever Kodandaran said, it perfectly makes sense. I just wanted to share one small view from my side. If you look at the consent section 6, subsection 1, it is very beautifully defined, maybe somehow inspired by GDPR, because that's the golden rule, that the consent should be informed, unconditional, and will be made available in the 22 languages recognized in the English version of our constitution. So I love this point, to be honest. And there is one more section, and this is on not only it. So if we read the sections, it might feels like that the bill is taking care of the organizations, banks, and all the institutions who are going to follow this. But as you go on and look at the last point, the point number 10 within the section 10, where it talks that where a consent given by a data principal is the basis of processing of personal data, and a question arises in this regard in a processing, the data fiduciary shall be obliged to provide that a notice was given by her to the data principal and consent was given by such data principal to the data fiduciary in accordance with the provisions of this act. and the rules have been made thereafter. So, so any sort of potential fraud which is happening now in the name of consent, like we see that there are cases going, we see in news that people are going to bank to do a fixed deposit, and maybe somehow they are being signed a document and they are ending up doing systematic investment plan where senior citizens are mostly targeted for these frauds. I think these kind of stuffs will see an end. That's one of the example. There might be many, but if a consent being available in the regional languages and a notice being given in a simple manner, like not 5-6 pages of terms and conditions, in a simple manner what is required, and if it's stored electronically or positively as an evidence that I am accepting it, like it happened in legal cases when you are giving a witness or something. So I think this is going to bring a beautiful framework of consent, and definitely we are taking care of the legitimate uses for sure. I'm pretty sure everybody have seen that. But
Yeah,
consent is the chapter that beautifully defined. Just wanted to share this.
good. Subraidu, you have got something?
Yes, sir. In fact, I was looking at looking at this red line version pretty useful, because it is like a track changes mode where you can easily track what was in the earlier draft and there. And you had asked a question of being consent heavy, right? I saw that some redlined sections in the bill where there are a lot of changes. The deemed consent has been struck off, and instead what you have under section 7 is the certain legitimate uses. Okay, and the wording change also indicates that, more accommodating and tilting to the GDPR concept of having more basis for processing personal data. So there are A to I sections are there. So it seems to be far less tilted towards a consent as the sole basis for processing, more towards adding more, recognizing more basis for consent. In that sense, is tilting more towards GDPR. I remember in the 2019 version, there are a lot of questions as to why is consent being deemed as the sole basis, and why can't we go more towards GDPR? It seems that that has been taken care of at least in this draft.
Yeah. Reena?
Yes, sir. Thank you. So just a query here. See, while the consent manager role has been identified, can data fiduciaries nominate consent manager and get the job done on their behalf?
Nominate, say ultimately this data consent manager will be loyal to the data principles. Okay. But of course, when there are 10 data principles in the market, maybe somebody can say, I prefer so-and-so or something like that, but they cannot be having any kind of relationship with the data fiduciary. That is, a data fiduciary company cannot tomorrow set up one subsidiary and say that will be the consent manager. That is not feasible. Okay. There has to be a kind of a distance between the data fiduciary and the consent manager. And there will be breach of trust issues coming here. It is a trusted relationship with the data principle. So one has to be very careful. All Tom, Dick, and Harry cannot become a consent manager. They should be committed to the welfare of the data principle. Maybe FDPPI can consider, but not all commercial organizations, so it will be very difficult. Yeah, Deepthi has got some.
I was coming from a point where, based on a business scenario, the company can identify a role and define the governance around it and get that guy or the consent manager to play that role on behalf of the company.
Consent manager business is a huge business. Let me tell you one thing. My own concept is, if a consent manager is there, he will be taking consents for, say, Jio. He will also be taking consents for Airtel. So his client base will be bigger than both Jio and say Airtel put together, kind of a thing. So if there is a real functioning consent manager, for example, one of the background verification companies today may tomorrow say, I will become a consent manager specializing in HR related activities. It's quite possible. So we have to look at that as a business proposition. one has to develop the business model for this, get the approvals of the Data Protection Board, but it is a great commercial proposition. Yeah, but you know that the risk is going to be concentrated in this particular organization. The risk of data breach is definitely going to be high. They have to be really be capable of addressing that. Yeah, Deepthi has got some question, I suppose.
Yes, thank you, sir. So coming back to the point of consent, taking consent. So I come from the banking background with experience in drafting some client agreements as well. So one, I see, yes, there is a big task for the financial industry right now to, if you actually follow the law to the T, that they are saying that it has to be clearly given to the data principal that this is the purpose and this is what we are going to use this for. Because right now what I am privy of is that it's a very round worded, not clear manner where you just take a consent that, you know, we'll be using your data, and the data is passed on to the subsidiaries like an insurance or a credit card. It's not actually directly applicable to the banking account which is being opened. So myself, when I was actually doing a draft for an investment company, and I incorporated the data privacy clause in it and wanted to make it more clearer, I was asked by the management not to go on into that elaborate details, because the details were going to be shared with another third party for the client analysis and everything. And the secondly, coming back to one of the points that somebody raised here was selling of a SIP to somebody instead of a fixed deposit. I think that is more on the side of a mis-selling concept rather than taking a consent. Because when you actually visit a branch for a fixed deposit and you are sold off, say, an insurance covered up in a in some manner, or an SIP to a wrong, that concept is actually a little not related to directly consent, because in that perspective, the client is not upfrontly signing off anything related to that. So that concept is more related to your mis-selling of a product.
Yeah. Now we are approaching 8 o'clock already, but let me go through quickly a couple of other important points. One is, of course, we have already made a reference to the duties of the data principal. Basically, the data principal is having the responsibility not to impersonate, not to raise frivolous queries, kind of a thing, which is all good for the industry. And also that in case of withdrawal of the consent, if there are any adverse consequences, probably some cost incidents would be there on the data principal. And in fact, in the penalty also, you can see the 10,000 rupees penalty is planned for them. Now, other than that, for the data principal, people are asking why there is no remedy of compensation for the data principal. Okay, so is this an omission? Is one question which we have to address. We know that even HIPAA did not have this right of direct legal remedy, because there are different laws in the country. Certain laws address the payment of compensation. Certain laws are for different purpose. For example, this particular law, Data Protection Bill, is basically a law to discipline the industry, try to bring certain norms of data processing to the industry. And therefore, it says that if these things are not done, we call it as non-compliance, and perhaps impose a penalty, which is huge, 100, 200 crores. In fact, Rajiv Chandrasekhar has confirmed today that, see, earlier there used to be a 500 crore limit. Now there is no 500 crore limit. There are 7 different categories of penalties, and these penalties can be aggregated. And Rajiv Chandrasekhar has even made a statement that if 1,000 data principals data is breached, the actual penalty can be 1,000 into 250 crores. So there is no limit on the upper side. It all depends upon the actual case-to-case basis analysis. And the Act says that before imposing the penalty, please take care of the status of the data fiduciary. Don't put 10,000 crores for fine on a company which has got no resources. So that guidance also has been given. So we know that Data Protection Board will apply penalties to a reasonable extent. Now, as far as the compensation is concerned, I have been of the opinion that compensation is very difficult to assess. Whether it's one aspect, it is like a judicial requirement. And secondly, there is Information Technology Act, which talks about the payment of compensation to a person who is affected by any contravention of the Information Technology Act, which will have section 43. 43A is going to be deleted, but 43 is going to remain, and 43 can cover all aspects of personal data protection breach, which this data protection bill can consider, which means that what perhaps the government may think is criminal consequences will not be there in this DPDPB. Civil, these things also will not be there in this. This is something only as an industry regulation kind of law, so that we will give a list of things to be complied with. If not, DPB will assess the penalty. So I think that has been the intention, though it is not difficult for government even to add at this stage that the Data Protection Board can also grant some kind of a nominal or whatever compensation to the data principal, because complaint can be made to the Data Protection Board. If a person is going to make a complaint, if he is not having any kind of a reward for that complaint, it looks slightly not very correct. So it can be added even now. But if it is not there, we may have to interpret it that they are leaving that to the Information Technology Act. We know that the government is now thinking of even in the Information Technology Act, taking out all the criminal provisions and putting it into a chapter in IPC and leave the Information Technology Act only for civil wrongs and adjudication in that respect. So government seems to be thinking that we will divide this into these three laws, which is the Data Protection Law will talk about disciplining the industry. Information Technology Act will provide compensation in civil terms, and IPC will take care of the criminal aspects, though data is there in all these aspects. So that is my reading of that. If anybody else has got any thought, they can come in. Kodanram. Yeah.
Sir, yeah, sir. What I feel is it is not Data Protection Act, it is Data Processing Act, because the aim of the act is totally changed. What was previously was to protect privacy of individual, and now the main aim of this particular act is to regularize data processing. So government has totally changed the goalpost in this particular manner, and that's why what you said is again it will be left to Information Technology Act, and the way adjudicating officers are processing, again data privacy will meet its means very bad fate in future, because the law without having any civil remedies or criminal remedies, it will be just for the benefit of industry for processing of data. That is my views.
Thank you. Yeah, Kodanram, just
yeah, sir, this is what earlier also I have spoken, very critical on that. In all these activities, we are looking at the principal who is a victim. Where there is no relief to the victim, what is the use of him engaging with the board, engaging with these people, fighting each other? He will instead use the IT Act Section 43. That itself is left them high and dry, because it's only a regular one which doesn't take privacy as a main core. And when we have a privacy as a core, which is especially Information Technology Act should not be limited to a jurisdictional things. Once you put it into IPC, it will become only for a state to do that kind of crime. We are not interested in criminally proceeding him. We are here to provide damages to him, civil damages to him under tort, crime tort. That should be the method. So that there should have been a clause here, whenever harm is happened and the victim can complain and claim his damages. And the proportionate of the damage could be, when for a penalty you can have so many columns. Is it not possible to have that? It is possible, but here, as my friend was telling, this is a data processing bill rather than data protection bill. It doesn't protect the personal privacy also. Only it provides revenues so that if the fiduciary wants, he can join. That's my opinion, sir.
I agree. Ketan wants to say something, and Anil Chiplunker has not spoken. If you have got anything, Anil.
So thank you. This is my very simple query. Basically, when you rename it as a digital, when you bring a digital part to the privacy part here, and where it says that it is only related to the digital safeguarding of the personal data. So what happens to those non-digital information? Basically, is there no accountability related to non-digital data? Like even today, we see all this KYC forms and everything. They are being filled, with handwritten things and other things. So there is no provision which speaks about safeguarding of those information here. Then,
no, if data is collected manually and subsequently digitized, it will come. Okay. So if it's collected manually and retained manually, processed manually, then it cannot come under this particular act.
So somewhere, sir, will that not defeat the purpose? But because when it is in a physical form, and if I create copies of it and distribute it, we know all those things basically which is happening. So that will defeat the purpose basically then.
Fine, I understand your concern. What the government perhaps thinks is our existing laws are sufficient to handle that situation. And what the Puttaswamy judgment highlighted was that the increasing risks which the society is facing on account of digitization of the economy. So they decided, let us first handle this difficult part of the digital privacy, and they have had this. And hopefully IPC and the constitutional right itself will take care of the smaller part of the problem, which is the handling of oral as well as written privacy violations. Okay, so I don't have anything more to say as of
okay, sir.
On that. Okay.
Thank you.
Yeah, Anil.
If it is a manual, it need not be processed. If you are going to process, means this act is coming. So if it is a manual, you are not going to process. Digital means process, speed. Now you are getting concerned. I am worried about the consent and other things. It will block. What is the purpose? The internet is the speed. You are going to control the speed in processing. Then another, actually, the victim is not getting compensated. You already mentioned. That's my point. Yeah,
I understand that there is that issue will remain. And at present, we have to say that, okay, it is covered under ITA 2000. Let us cover it under that. Tomorrow, if government wants to add this here, I will be quite happy with that. Yeah, Professor Avinash, can you come back? I think we have completed.
Yes, sir. Yeah, I'm here, sir.
I would like to have a final word from Avinash.
No, I would like to comment only on this. No, I think, see, it's an interesting debate. I'm really enjoying. The only thing, this compensation part, I think the problem with our Indian regulatory bodies, especially the new upcoming bodies, we don't believe in punitive damages. And then there is a less participation even from the industry and the stakeholders. So, like, I can share my experience in the competition law. So the competition law, there is a provision that the affected parties can go for the compensation. I tell you, last 10 years, we haven't seen even a single case which we have seen that, okay, somebody got a money as a compensation. So yes, I agree with this point that when we want to empower people, if you want to create awareness about this data privacy law, to some extent, I think we should give the compensatory part also. Instead of focusing on too much penalty part, I think government is very concerned about putting more and more penalties. But if you see the last 60, 70 years history in the market, penalties normally don't create any deterrence for the big corporations. So for maybe individuals, 1 billion or like 5 billion, 10 billion looks a big amount. But companies like Meta, Google, Microsoft, it's not like a big amount. They have already integrated those penalties in their accounts. So I think if you want to empower people, if you want that, like somebody was telling that in villages, we can't create awareness. No, I believe that if we start giving some incentive as a compensation to the victims, and automatically the citizens movement will start at the grassroots level, and then we will see more awareness at the national level also. So I think, sir, that's my final comment, and I think it was a really amazing program. Thank you.
Thank you. Thank you, friends. Of course, this sort of a discussion, any amount of time we have will not be sufficient, but we have tried to restrict it to 1 hour plus another 10 minutes extra we have taken. I thank all the people who have participated, and obviously there will be more occasions in which we will be discussing DPDPB, and our own understanding will also evolve. And of course, there will be discussions in the parliament, and notifications which will come will add to the lot of points which we need to debate. So with that, I would like to thank all of you, and then close this particular session. Dr. Naveen, you have got anything to say? Anybody else who have not had opportunity to speak wants to say the final comment? Either you can speak out or put it in the chat box.
I just wanted to...
Navi.
Yeah, Padamalai, you want to say something?
Yeah, sorry, when you called out last time, there was an audio issue. I could not speak that time. So thanks for organizing this, Navi. And my couple of points overall, 2 points I want to put in. One is on the design side, another is on the implementation side. So first of all, I think it's a good start. As we know, that it's a long pending thing. Hence, however, it may not be completely satisfying all the requirements. There's gaps. I completely agree with many of the points raised by our fellow members in other many others raised. It's very, very valid, right? From compensation, consent managers, rural education. There are a lot of points which are very valid. To me, the takeaway is we are starting somewhere. That's a good sign. That's the first point, right? And then the coverage is much more simpler. That's also a very good sign. The design side, I feel that personally, my opinion is there are some qualifiers, government to take a lot of authority. There are some qualifiers, but I somehow personally feel that's not good enough. It has to be much more detailed, much more transparent to ensure that the government is not going to misuse or abuse powers. That's the first point. Then we talk about data protection board. I think that also requires to be, we'll have to see how it is going to evolve. My own personal thought process is something like this is much, very, very vital, especially we talk about digitization. Hence it's very, very vital. So it has to go to the stage of separate act for data protection board, like a RB Act 1935, something like that. If not now, somewhere down the line, we'll have to reach that stage. That's on the design side, both the government side and the data protection board, authority, transparency, a lot of individual points talked about quorum and the members, expertise, a lot of things are there, but it has to go much deeper to show really the intent of independence. Now come to the implementation side, I would sum it up with only one line. So I don't know who talked about this. We are trying to move away from digital illiterate population to digitally literate. So that's a challenge we have both on security and as well as privacy. It's like a chicken and egg, right? Somewhere it has to start. So we are starting here and we have a long way to go in the form of education. So that's a long way to go. There are a huge amount of challenges. I'm not talking about just rural. Even the companies powering the BFSI, security or privacy, we have a long way to go. Even culturally, privacy as a country here, we have a long way to go. So in summary, I would say it's a good start. But I think the design level parameters, if you are able to fine tune, implementation probably we can see how do we fast track. That will be my take.
Thank you. Thank you for your nice final words. Thank you, friends. So let us close this session. We will meet again at next opportunity. Bye.
Thank you. Thank you so much.
Thank you, Navi.
Thank you, sir, for calling us.
Thank you. Thank you, Baburaj. You were silent listening. Okay.
Thank you, Ravi. Thank you.
Thank you for such a knowledgeable session. Thanks a lot.